your visits to her last summer?
I liked her, yes.
You became very involved with her case?
No more than the other cases I was handling.
Oh, come now, it was not over the other cases that you demanded a transfer.
No, but
you
there
felt
were...
so deeply that you had an argument with your director about it.
Even
an
so...
argument that could seriously jeopardize your career in the service. Isn't that true?
I suppose so.
Just as you're coming here to court today and giving evidence in the manner that you are doing, just as that could jeopardize your future.
Look, if it's a question of my career or justice for Sheena, you don't think that I'm going to stand back
and... it's just that I wonder if there isn't something a little less noble than justice that's motivated your coming here today.
My lord, you're prepared to justify that, of course.
I fully expect to do so, my lord. Miss James, you say that you concluded that Mrs. Smithson's prior confessions of violence against baby Peter were invalid because it was something she'd just made up.
Yes.
Well, why did you not report it then to the director?
Well, obviously I wasn't going to. It'd simply have scrapped her visits.
Because it'd have realized that the whole thing was a trick to get better accommodation.
Well, I wouldn't say...
So it was a trick. And that is why, when Mr. Webster failed to fall for it, you felt no anxiety about asking for a transfer.
Anxiety?
Well, your transfer meant that you'll be leaving Mrs. Smithson to get on with it.
Well,
her one ally in this campaign of hers, and you were quite happy to pull out and leave her to it.
She needed...
Leave her to her disastrous marriage and her grotty flat. And then what happened? Within 5 weeks of your going, 5 weeks, Miss James, she had a comatose child and a charge of attempted murder against her. And that, I suggest, Miss James, is why you are here to plead her innocence, your sense of guilt.
No, not in the least. As I say, it was simply a question
Do you deny that you have a reputation for siding with the mothers in these child abuse cases?
I don't know what you mean.
Well, isn't it true that you associate too closely with the mothers? You become over-involved.
No.
You are unable to admit that they are capable, even under dire stress, of these flashes of insane cruelty. Isn't that so?
No.
And that is the reason why you've asked for this transfer. You recognize your inability to cope with these cases, and so you asked to be transferred to Liverpool, where you could deal almost entirely with juvenile delinquents and drug abuse cases, correct?
It was the accommodation.
No, Miss James, that was just incidental. That's what brought it to a head. You said that yourself. We can always recall Mr. Webster and ask him, you know.
Oh, he'll say so, no doubt.
And your other colleagues?
Look, I'm not denying that I'm better at dealing with teenagers, but that doesn't mean to say that I misjudged Sheena.
Well, I suggest that you did, Miss James, and that you know it. You left her, and had you not done so, she may not be sitting in the box where she is today.
No!
And young Peter may not be in hospital, a possible vegetable for the rest of his life.
Oh, my lord. Miss Tate, I suggest that you should be the last to talk about over-involvement.
I apologize, my lord.
Have you any further questions to put to this witness? Miss James, have you any reply you would like to make to counsel's observation?
Thank you, my lord. It's just this, sir. If I do seem over-anxious about Sheena Smithson, it's nothing to do with guilt. It's because of the consequences if you find against her. I deal with delinquents, yes. And all I can say is if you want to turn these Smithson children into candidates for delinquency, then go ahead. Break up the family, condemn them to institutions, or even worse, into the care of that woman, their granny. Go ahead, it's your choice.
Thank you, Miss James. No re-examination, Mr. Lotterby?
No, my lord. Thank you, Miss James.
You may stand down.
That concludes the case for the defense, my lord.
Miss Tate.
Members of the jury, it is hard to address you dispassionately in this case because the issues involved are so emotive and tragic, and on both sides. On the one hand, we have a young woman, a mother, with evident love for her children, but she is the victim of dire domestic stresses, a disastrous marriage, inadequate accommodation, and a state of anxiety that she has admitted reduce her to these black moods of hate and despair. On the other hand, we have a 15-month-old child with appalling brain injuries. Injuries he could well have suffered as a result of one of these moods. Now, she has denied this, pleading instead that it was all a ghastly accident. But surely, under cross-examination, her account of the accident emerged as woefully contrived. For instance, the slam of this car door, heard 4 stories below and over the sound of a television set. Concrete stairs on which no traces of blood could later be found. And then the child himself, with whom she had admitted being severe and twice losing control. Clearly, she is guilty. But in confirming this, do not imagine that you are subjecting her and her children to some form of Dickensian oppression. The process of our laws is now mercifully enlightened in dealing with cases such as these. You see, the object is not to punish the parent, as to empower the state to take remedial action. Now, some of you, parents yourself maybe, will feel great sympathy for this woman. But how will you feel if next year, if you decide to acquit her of the charge, how will you feel if you read in the newspapers that young Peter is dead, struck down with similar injuries incurred in a similar situation? What are your feelings then? Members of the jury, you have a duty in this case, and it is a merciful one, to find the accused guilty as charged.
My lord, members of the jury, let us be clear as to what the prosecution would have us believe. That the defendant is a monster, a brute, who, picking up some heavy instrument, struck her baby with such force, such ferocity, as to cause him serious brain injuries and put him in a coma. Now, can you believe this of the woman you've come to know here in this courtroom? However distraught she may become, can you believe this mother who so loves her children that they are to her whole life, can pick up some heavy object and smash her baby over the head? And can you believe she then wiped the heavy object clean so as to fool the police forensic experts? No, members of the jury, it simply won't do. Indeed, the prosecution has brought forward so little real evidence that you may well ask yourselves how this case ever came to court. Well, the answer to that is simple. Certain people took it upon themselves to go to the police. Oh, let's look at these people, shall we? The mother-in-law, who saw that here was a chance to discredit her son's wife and gain control over his family. The husband, a weak character who has been engaged in what can only be described as open warfare with his wife. And Mr. Webster, the senior social worker, who had been led to believe that my client had twice lost control over her child. Now, the police did not check on these informants. They did not know of the hate and prejudice of the husband and the mother-in-law. They failed to unearth the ironic truth behind Mr. Webster's evidence that Sheena Smithson had said what she did as part of her desperate campaign to get her family into a better home. Members of the jury, mere accusation is not enough. Certainly not enough for you to separate this mother from her children. And I ask you to acquit her of this absurd and wicked charge.
Now, about this charge of attempted murder. In order that that should be proved, the intent to murder has to be proved, and in my opinion, insufficient evidence has been advanced to support it. I therefore direct you to acquit on that charge. Miss Tate, do you wish to challenge that instruction?
No, my lord.
I wish you only to consider, therefore, the alternative charge of attempting to cause grievous bodily harm. Now, this has been for you, at times, a harrowing and emotionally charged case, not the least during the closing speeches. You heard references to brutes and monsters, to what your feelings might be should young Peter die next year, and it is my duty to urge you to put all these sentiments out of your mind and to look at the case from a purely dispassionate point of view, as the law requires of you. Now, all the evidence you have heard is circumstantial evidence. That is, you have no physical evidence, such as fingerprints on a blood-stained weapon to prove guilt, any more than you have a blood-stained staircase to support innocence. Instead, a picture has emerged of the sad circumstances of the Smithson marriage. A sad picture of disputes, jealousies, tensions, sometimes violence. A picture all too familiar in this age of social tensions with its attendant problems of housing, inflation, and so forth. Indeed, you've heard the evidence of Dr. Park, who has said that amongst his patients he has many young mothers whose dilemmas are just as extreme, if not more so, than that of the defendant. Sheena Smithson. Now, she has admitted that these marital tensions drove her to moods of a dire nature, but she insists that the moods were never bad enough to drive her to the extremes of violence suggested by the prosecution. then you have heard what you may well consider to be the most damning evidence of all, that of the director of the Fulchester Social Services, who says that in May the accused confessed to him prior assaults on baby Peter, saying that she could no longer trust herself with him. But this evidence was strongly challenged by the social worker, Miss James, who discounted these confessions as mere pretense in order to gain for the family better housing. And that brings us to the accused's explanation as to how the child's terrible injuries were incurred. Now, if you believe her story of hearing the car, seeing the washing machine, leaving the flat door ajar so that Peter could crawl out along the balcony for that fateful tumble down the stairs, if you accept this, then you must acquit. If, on the other hand, you feel that the prosecution was successful in discrediting this story, then it is your duty to find her guilty as charged. The members of the jury, you will now please withdraw and consider your verdict.
All stand. Members of the jury, will your foreman please stand? Just answer this question, yes or no. Have you reached a verdict upon which you are all agreed?
Yes.
Do you find the prisoner Sheena Smithson guilty or not guilty of attempted murder?
Not guilty.
Do you find the prisoner Sheena Smithson guilty or not guilty of attempting to cause grievous bodily harm?
Not guilty.
You are discharged and may leave the court.
Court will rise.
A fortnight after the trial, Peter underwent further brain surgery, which proved so successful that he was allowed home from hospital within the month. Next week, a chance for you to join another jury in assessing the facts when our cameras return to watch a leading case in the Crown Court.